But we submit that the materials that are obtained pursuant to search warrant and subpoenas and the judicial instruments themselves are fall under the Tennessee Public Records Act, because once those materials are swept up in the dragnet requested by law enforcement, they then become materials received by law enforcement and fall under this court's holding in TSSAA that they are public records. And Your Honors, true
well,
that
TSSAA had no constitutional issues such as the right to a fair trial or a victim's rights to be immune from harassment and humiliation. This was a whole different ballgame.
Well, Your Honor, let me.
And while I'm on that point, I might as well get to it. I admire the fact that you and your clients have expressly said you do not wish to see and do not wish to have exhibited photographs or videos of the victim or anything that might embarrass her. The problem is, if we give you what you want, everybody on the face of the planet will have the right to see those things. I'll call a request. All they have to do is walk in and say, I'm here, I want to see those photographs. And they can put them on any media they want.
Your Honor.
So how do we honor the victim's rights, constitutional rights, if we accept your argument that anything in that file is a public record or a judicial record?
If their interpretation prevails, the video and pictures involved in this crime and any crime will be available to any Tennessee citizen.
What you're talking about, this information that is being assembled, it's not publicity. And I want to make that very clear. This is not a case about publicity. It's not about pretrial publicity, articles that the newspaper or the media have written about the defendants or the victim or what has already been reported in the press. This is a case about evidence. This is the evidence that has been collected by Metro Police. Evidence that which the trial court found has not yet been tested by the crucible of the provisions under state and federal law for determining whether or not it's admissible.
Frankly, this is a scary case. It scares me because as a former prosecutor, I think I know what might have happened if the original inquiry to the police department of Davidson County, or possibly the later inquiry to our mayor, had simply been granted. The video of a horrific sexual assault, the video of my client being dumped in a hallway at one of America's great universities, the text messages describing and possibly even celebrating, if that can be comprehended, the horrific crime would be disseminated throughout the world because of the internet age in which we live. And the victim would never have been given the right to even protest. That's why we contend, may it please the court, that this hearing is possibly the most important hearing in victims' rights in the last 24 years since the Victims' Rights Statute was enacted and then later the constitutional amendment.